Attorney General.
Thank you very much, Mr. President, for the opportunity to contribute to the debate on this motion, which is an important motion, because at the end of the day, after all of the back and forth, what really is at stake here is the national interest. It's as simple as that. And it is the national interest for the reason that the material misstatements which the Treasury Division of the Ministry of Finance has attempted to bring to the attention of the Auditor General so that she may properly take it into consideration will impact the credibility of the financial reputation of this country, either positively or adversely. And let me make it very clear in everything that I say today, and by way of emphasis of what I said in the other place, that I am not attacking the Auditor General. I accept the point that Senator Thompson Ahi has made. This is someone new to the position. She needs the support and the assistance that she can get. And at the end of the day, just to make a point in relation to Senator Ahi, when I wrote to the Auditor General to say that I was unable to give her the advice, bearing in mind Section 10, subsection 1G, I believe it is, the section that Senator Ahi referred to, it was not that I was in dereliction of my statutory responsibility. The fact of the matter is that, as a matter of record and historically, I was already advising the Minister of Finance. And therefore, on the first application of the ethical standards which I subscribe to as an attorney at law and certainly as a member of the inner bar, it would have been a conflict of interest for me to be both advising the Minister of Finance and the Auditor General on the same issue. And what I did is I said to her, get independent advice, and as Attorney General, I undertake to pay the reasonable fees of whoever you get to give you that advice. That was my response to the Auditor General, because I recognized at that point that the best advice that the Auditor General could get was good advice. I was not available to give it to her. She's new to the job, and she would benefit from good advice. Mr. President, I'm going to, with those few preambular remarks, I'm going to begin where I ended in the other place for an important reason. Where I ended in the other place was to cite from a Court of Appeal decision of the Court of Appeal of Trinidad and Tobago. And it is important that I cite it again as I begin my response this afternoon. The Court of Appeal decision, Civil Appeal number 10 of 2004, Director of Personal Administration and Police Service Commission against Cooper, Barbosa, and Burjar, the judgment of Chief Justice Sharma, 2005, at paragraphs 28 to 29. That dictum has been approved in a number of cases since then at the level of the Privy Council on the doctrine of separation of powers. This is what Chief Justice Sharma said in 2005. In all constitutions based on the Westminster system of government, there is in operation the doctrine of the separation of powers. By this doctrine, the autonomy of each branch of government is presumed to be immune from undue encroachment from any others. Thus, the legislature, the executive, and the judiciary operate in an environment which is presumed free from influence from each other's sphere. While in the popular sense, it may be convenient to divide the powers of government into three spheres, and I emphasize this, in practical reality, such rigid classification is neither desirable nor possible. On the basis of the doctrine as initially formulated by French jurist Montesquieu 16 Esprit de Loi, Book 11, Chapter 6, what is desired, and I emphasize this, is not that the different organs, such as, not exclusively, such as the legislature and the executive, should have no influence or control over the acts of each other, but rather that neither should exercise the whole power of the other. That is what the separation of powers properly understood means, that the different arms of the state, whether it be the legislature, the executive, the judicature, or the Auditor General, or the Director of Public Prosecutions, or other independent arms, it is not that they must not speak to each other. Separation of powers doesn't mean that you wrap yourself in an ivory tower and decline to engage with the other arms of state. It means that you must engage, but in the engaging with each other, you respect the territory of each so as not unduly to encroach on the other. And in the Treasury Division, coming to the point, in the Treasury Division, beseeching the Auditor General, and I will make a short point before I continue, who clearly was not getting good advice. And I say this to say that I would encourage the Auditor General to proceed from here on the basis of good advice. Clearly, in the entreaties that the Treasury Division were making to the Auditor General, she was getting advice to suggest that on the basis of Section 116, subsection 6 of the Constitution, she was not to receive from anyone any information. 116, when she wrote to me through her legal officer, and when she wrote through her legal officer to the Treasury Division of the Ministry of Finance, they underlined Section 116, subsection 6, and put the words next to it on behalf of the Auditor General, emphasis mine. And what Section 116.6 says is, in the exercise of his functions under this Constitution, the Auditor General shall not be subject to the direction or control of any other person or authority. The Auditor General was being badly advised, and I dare say continues to be badly advised, as to the meaning, substance, purport, and effect of this subsection. It does not mean that the Auditor General is not to speak with anyone or receive from anyone any information. And I refer in that vein to the essence of why that cannot be so. My colleague, Senator West, referred to the International Accounting Standards, Auditing 560, and to Standard 6. The auditor shall perform audit procedures designed to obtain sufficient audit evidence that all events occurring between the date of the financial statements and the date of the auditor's report that require adjustment of or disclosure in the financial statements have been identified. What are the dates here? The date was the 31st of January, 2023, when the Treasury Division submitted the accounts for the year 2023. That's the date when the Auditor General received the accounts. The next relevant date was the 30th of April, which was the prescribed due date under the Exchequer Audit Act on the computation of the time from the 30th of September to 30th of April, by which the Auditor General was required to submit her report. And the accounting standard by which she is obliged to operate requires that between those two dates, she must receive all reports. She must receive all information for the purpose of verification. It's very clear. And that takes me to a false point that Senator Mark, but one has come to appreciate that this is the area of Senator Mark's forte, wishes to mislead this population on. He says that there is a breach, or words to this effect, I'm not attempting to quote him, by the Minister of Finance in claiming that he has any function to play in the submitting of the report and laying of the report before the Senate today or before the House on the last occasion. And Senator Mark holds up the Constitution. He walked with a book that looked something like mine, and he declared it to be the Constitution. I have no doubt it was. And he says, I have the Constitution here, and he read from Section 2. Well, I don't need to read from Section 2. I know it. It is the Supreme Law Clause. It says that the Constitution is the supreme law of this republic. Yes, but a Constitution, like all other laws, must be interpreted to serve its purpose and its intent. So what does Section 116 of the Constitution say, which is what Senator Mark, misadvising himself, seems to want to rely on? Section 116 of the Constitution, subsection 4, which he cited, says the Auditor General shall submit his reports annually to the Speaker, the President of the Senate, and the Minister of Finance. Subsection 5, Section 116, subsection 5 goes on to say the President of the Senate and the Speaker shall cause the report to be laid before the Senate and the House of Representatives, respectively, at the next sitting of the Senate and the House of Representatives after the receipt thereof, respectively. So the Auditor General sends her report to the Parliament in the persons of yourself, Excellency, President, and the Speaker, and either the President of the Senate or the Speaker shall cause the report to be laid. The Constitution does not say that the Speaker or the President of the Senate shall lay the report. You find that in the Exchequer and Audit Act. Section 25(3) says the Minister, and this is a reference to the Minister of Finance, shall lay the report. Note the difference in language between Section 116(5). The President of the Senate, I'm reading from 116(5), the President of the Senate and the Speaker shall cause the report to be laid. The prescription is provided for in Section 25(3). The prescription is the Minister shall lay the report of the Auditor General on the table of the Parliament within 30 days of its receipt. So you read the Constitution together with the law that prescribes the specific functions to be performed by the functionaries within the Exchequer and Audit Act. And we remember when we read the Exchequer and Audit Act, this act was passed as a law of Trinidad and Tobago, as Act number 20 of 1959. So this act came into force before the Independence Constitution and has existed through the passage of Trinidad and Tobago's independence and through the passage of Trinidad and Tobago's Republican Constitution status. It is, in other words, a saved law. And therefore, it must be, on principles of construction, read as a saved law that is beyond challenge as a law of this country, together with the Constitution, and therefore cause to be laid by this President and the Speaker of the House, by the Minister, Section 25(3), actually laying it on the table within 30 days. So there is no violation or breach on the part of the Minister of Finance. And the advice which Senator Mark has given to himself on the constitutional breach, there's no constitutional breach. The advice which he's given to himself on the basis of his understanding of the Constitution, with respect, is flawed. If I may continue, Mr. President, my duty here today really is to speak to my understanding for the benefit of all listening, including the Auditor General, my understanding of how the law is intended to operate in this impasse that we find ourselves in. Section 24 of the Exchequer Act makes it very clear, Mr. President. It requires the Treasury to cause the account showing fully the financial position of Trinidad and Tobago to be transmitted to the Auditor General within a period of 4 months after the 30th of September in each year, or such longer period thereafter as Parliament may by resolution appoint. So as a general proposition, if the Treasury proposed to submit accounts for whatever reason after the 31st of January of a particular year, and the 31st of January being the 4 months after September in the year before, that time would have to be extended by the Parliament. In this case, the Treasury submitted the accounts on time, but later discovered errors and brought these to the attention of the Auditor General. The Treasury was obviously, Mr. President, bound to do so, because its obligation was to provide the Auditor General with accounts showing fully the financial position of Trinidad and Tobago. And it discovered that the accounts submitted, if it discovered that the accounts submitted were indeed not full and did not represent the financial position of Trinidad and Tobago. Mr. President, we have heard from the Honourable Minister of Finance. We understand in the very clear explanation that he gave us today of the error that occurred, the double booking error, as between the Central Bank and the Board of Inland Revenue in the information that eventually came to the Treasury Division. It is the Auditor General's duty, both with respect to the international auditing standards to which I have just referred, and Section 9 of the Exchequer and Audit Act, to audit those accounts. And to that end, she has the power under Section 10(1) to call on any officer for any explanation and information between the period 31st January 2024 and the 30th of April 2024. It is her duty under Section 10(1)(b) to authorize, if she doesn't get the information she's looking for, when the Treasury Division came to her and provided her with information, it was her duty to accept the information, and then under Section 10(1)(b) to authorize one of her officers to conduct a further inquiry, examination, or audit. And under Section 10(1)(c), if she was not happy or satisfied with what the Treasury Division were giving her to explain this double counting error, she could send for and have custody of books, accounts, vouchers, papers, and in any wise, I'm quoting from Section 10(c), in any wise concerning the public accounts between the period 31st of January and 30th of April 2024. Implicit in the performance of the Auditor General's powers is the possibility and the acceptance of the possibility that during the course of her audit, errors may be discovered and noted and corrections accordingly made. Mr. President, the plain, ordinary English dictionary meaning of audit is an official examination and verification of financial accounts, especially by an independent body. That's the plain, ordinary English language definition of the word audit. An examination and verification. How do you verify? You call for information. You admit persons who wish to give you information. You look at it and you say, I'm not satisfied with this. I want a better explanation. And you send for more information. That is the process of verification. And that is what an audit is about. You don't lock yourself away. You don't lock your doors. And she was misadvised. Clearly, she was being misadvised. You don't lock your doors and refuse entry to persons who are seeking to help you to get it right in the process of the audit. And it is a fallacious piece of advice to persuade the Auditor General that by reason of Section 116, subsection 6, because she is an independent institution under the Constitution, she can lock herself into the waterfront towers and not allow anybody any access to her because she's independent and not subject to control or otherwise. It is fallacious advice. And I regret that she is new to the job. With all the promise that she has, she is being given bad advice. Mr. President, just as much as the Treasury is obligated to present the full financial position of Trinidad and Tobago, so too is the Auditor General required through her audit to determine whether the full financial position of Trinidad and Tobago has been presented. There was nothing untoward, nothing illegal, nothing wrong about the Treasury notifying the Auditor General of errors in the accounts and providing her with information which would have allowed corrections to be made. Nothing wrong. It was their duty. If they had failed to do, and I will come to the detail in which they tried to do it, if the Treasury Division had failed to do that which they tried over 2 months to do, they would have been in dereliction of their statutory duty under the Exchequer and Audit Act. Mr. Speaker, you've heard from the Ministry of Finance as to the cause of error, the concerted efforts, including concerted efforts made by officers of the Treasury Division, including her refusing entry to persons. And so alarming was the conduct of the Auditor General that the Minister of Finance came to me as Attorney General and asked my advice. I gave advice and I recommended a very eminent senior counsel and a very eminent senior junior counsel to advise him, and they have given him advice on an ongoing basis since this thing has developed from early March all through to now. And as a result of that advice, the Minister of Finance, given the deadline of the 30th of April that was approaching, given the material misstatement, the magnitude of the material misstatement that this Auditor General was on advice, declining to even consider, was persuaded, on good advice of senior counsel, to cause a pre-action protocol letter. So my secretariat, the Attorney General's secretariat, on behalf of the Minister of Finance, settled by senior counsel, wrote a pre-action protocol letter to the Auditor General. And that pre-action protocol letter outlined the narrative of events, Mr. President, starting with the 31st of January, 2024, when the financial statements for 2023 were submitted to the Auditor General. I'm not going to read that statement, that pre-action protocol letter. It's 8 pages long. But I'd like to highlight the narrative sequence of efforts that were made. So in that letter, the pre-action protocol letter, settled by senior counsel, addressed to Ms. Jayanti Ramdas, dated the 15th of April, starts off by reminding her that she received the Treasury Division's revenue statement under Jayanti. I beg her pardon, I may have mispronounced her name. On the 31st of January, 2024. That was the start of the sequence. And thereafter, in this 8-page pre-action protocol letter, you have a record of events. The error was brought to the attention, or was discovered by the Treasury Division in late February of 2024, a week of the 26th of February. And on the 25th of March, having spent the 25th of February to 26th of March cross-referencing amongst themselves the different institutions that the Minister of Finance has told us about today, and verifying to make sure that this alarming material misstatement was correct. A call was put to the Auditor General on the 25th of March. She received the call and said she couldn't speak and she was on her way home and she would call back. She did not call back. All of this is set out in the pre-action protocol letter. On the 26th of March, the Permanent Secretary of the Ministry of Finance, not having heard from the Auditor General, sent her a WhatsApp message at 10:11 of that morning and elaborated in the WhatsApp message the concern why the Treasury Division of the Ministry of Finance needed to have an audience with her. Subsequently, the Ministry of Finance was contacted by an Assistant Auditor General. A meeting was scheduled for the 27th of March, 2024. At that meeting, everything was brought to the attention of the representatives of the Auditor General, and the Assistant Auditor General, requested certain documentation, indicated he would report the matters discussed at that meeting to the Auditor General. On the 28th of March, not having received any further communication from the Auditor General, again, the Permanent Secretary called the Assistant Auditor General to inquire and was informed by the Assistant Auditor General that the Auditor General would not be issuing any communication to the Ministry of Finance and that the Ministry should write to the Auditor General with respect to any material misstatement. So that was immediately done. 28th of March, memoranda by email was sent to the Auditor General, setting out the details of the material misstatement. It explained the process by which the understatement was identified and quantified, etc. On the 5th of April, the Permanent Secretary submitted further material to the Auditor General's office, in particular setting out the error with the central bank and the new electronic clearing system. On the 8th of April, a further memorandum is sent to the Auditor General, setting out by the Permanent Secretary of the Ministry of Finance and the Treasury Division, setting out details. On the evening of the 8th of April, the Comptroller of Accounts sent an email to the Auditor General, advising that a compact disc containing electronic copies of the amended public accounts would be delivered to her office on the morning of the 9th of April. On the morning of the 9th of April, the Treasury Executive attended the office of the Attorney of the Auditor General to deliver that compact disc. On arriving at the Auditor General's office, that Treasury Executive was told by personnel in the Auditor General's department that they had been instructed by the Assistant Auditor General that he was instructed not to accept the compact disc containing the amended public accounts. After being informed of that refusal, the Comptroller of Accounts attempted to call the Auditor General on a landline on the 9th of April. The calls went unanswered. A WhatsApp message was sent. No acknowledgement. On the afternoon of the 9th of April, the Treasury Director, her senior Treasury Account Financial Assistant Management Branch, and the Treasury Executive went to the office of the Auditor General to deliver the Permanent Secretary's letter of the 9th of April together with the compact disc. On arrival, they were told there was no one there to receive those items and they should return on the 11th of April 2024. On the 11th, they returned. They met with the Assistant Auditor General, who told them that he was instructed by the Auditor General to accept only one of the two CDs, the compact disc containing the original 31st of January 2024 financial statements, but not to accept the compact disc containing the amended public accounts. The officers cautioned the Assistant Auditor General of the ramifications and implications of presenting the public accounts without making the amendments or considering the amendments that were being requested. At the request of the Auditor General, those three officers then met with the senior legal officer of the Auditor General's department and they asked her if the amended public accounts could be audited before the 30th of April 2024. The senior legal officer then excused herself to consult with the Auditor General and on her return indicated that she too was instructed by the Auditor General to accept only the compact disc containing the electronic copy of the original public accounts that were based on the 31st of January 2024 public statement and not to accept the compact disc containing the amended public accounts. I use the word in the other place and I use it here now, Mr. President. It's bizarre. There is no explanation for this, no matter what one reads on the front pages of the newspapers and letters that are being written, pre-action protocol letters that are being written by other persons, misstating the facts. This is the record. And having received this pre-action protocol letter and given a deadline to respond, the Auditor General responded on the very day, the 15th of April. And in her response, she said, and the Minister of Finance has already read this out, the Ministry of Finance is free to submit an original signed and dated letter to the Auditor General by 12 noon on April 16th, recalling the public accounts previously submitted and dated January 31st, 2024, confirming the statement of declaration and certification previously provided as inaccurate and providing the revised public accounts, and this letter will be published in the Auditor General's report. I was told by the attorneys in my office that it was their expectation, having received this letter, and the Treasury Division persons having complied with this request, that they had assumed that the situation had been resolved.
All of us.
That the Auditor General had now accepted she would receive the documents and would proceed to consider that which had been provided to her so that she could include it or say otherwise in the report that she was required by law to lay with the Parliament on the 30th of April. And the next thing that we know is the Ministry of Finance gets word that on the 24th of April, with no further word, a report has been laid in the Parliament, which does not include any of the material that had been provided and the Auditor General had agreed to accept. It is nothing short of bizarre, Mr. President. And that is the very regrettable state of affairs that existed at the date at which, well, no, this was before. So on the 17th, before the 24th of April, I then received the letter from the Auditor General asking me for advice. And because of what I have already explained, a conflict of interest, I'm advising the Auditor, the Minister of Finance, I wrote to the Auditor General. I did not, as Senator Roberts has said in this House, and that's why I sought to ask him to give way, and he declined, I did not say I had taken a position against the Auditor General. What I said to her in my letter, and I will read it for the record, Dear Auditor General, dated the 19th of April, in response to her letter to me of the 17th of April, asking for my advice, I said, I acknowledge receipt of your letter dated the 17th of April, 2024, with attachments, requesting my advice on whether the Auditor General is required to consider the amended statements referred to in your said letter. In light of the provisions of sections 24 and 25 of the Exchequer and Audit Act, consistent with my duty under the Constitution, and as you are aware, I am already advising the Honourable Minister of Finance on this very matter. I refer in that regard to the pre-action protocol letter dated the 16th of April, which is one of the attachments to your letter to me. So in her letter to me of the 17th, she attached the Attorney General's Secretariat letter from my ministry, which had been written to her. So I say to her, in the circumstances, it would be inappropriate for me to render any advice to you in this matter. I did not say to her, as Senator Roberts has said, that I've already taken a position against you. I said it would be inappropriate for me to render any advice to you on this matter. I was cognizant of Section 10, which Senator Ahi has referred to, but even though the Auditor General can come to me with a request for written consideration and advice under Section 10.3, in the circumstances of the conflict that I found myself in, I said to her it would be inappropriate. I then said to her, I recommend that with all appropriate urgency, bearing in mind that I was writing on the 19th of April and the deadline date for the report to be submitted is the 30th of April, I said I recommend that with all appropriate urgency, you should retain independent counsel to give you such advice. I give the undertaking that as Attorney General, I am prepared to pay reasonable fees incurred by you as Attorney General for the retention and obtaining of that independent advice. Sincerely yours. That's the last communication we had. The next thing we knew is that the report had been laid. 5 days, 24th of April, 5 to 6 days before the deadline date. So that we find ourselves in this remarkable situation, Mr. President, where the Minister of Finance, to his credit, has no choice. The Auditor General is being misadvised, and we hope that situation can be corrected. We are in a situation in which audited reports of a National Auditor General are before the Parliament, omitting significant information. A report is before the Parliament with an offer over a period of March to April 2024 to give all the support and assistance that the Auditor General could possibly require to accomplish and conclude her report. And all that we are asking for in this very unfortunate situation that we find ourselves in today is that this House extend the time so that we can bring the heat down. Very regrettably, there was no need for the heat to go up, and give the Auditor General some time.
AG, you have 4 more minutes.
Thank you very much, Mr. President. Give the Auditor General some time in which to do that which she is required by law and by the international audit standards to do, and that is to take into consideration relevant information to verify her audit between the date when she received the financial statements and the date which hopefully this House will extend by which she must submit a report. And before I close, let me make it very clear, Mr. President. In my view, and it is a view shared by senior counsel who have been advising the Attorney General, the circumstances that we find ourselves in, that is to say, the report was submitted on time, but errors are discovered after the fact. That does not necessarily require us to have come here for a resolution to extend the time. It was perfectly lawful on the definition of audit, on the accounting standards, and the provisions of sections 9 and 10 of the Audit Act for the Auditor General to have received the information which the Treasury Division has been trying to put at her disposal. It is only because we are now forced into this near impossible situation that we are before this House for the extension that we request. Mr. President, I end where I began. This is about the national interest of Trinidad and Tobago. It is not about gamesmanship. It is not about scoring political points or embarrassing anyone. And it is certainly not about attacking any constitutional office. It is simply about the fact that what is good for this country is that the true accounts should be stated so that at the end of the day, we can continue to do business with the world on a verified, true, and correct audit report. And Mr. President, with those words, I support the Honourable Minister of Finance, and I ask that this resolution be passed.